First say, what we're talking about here is an authority in Dodd-Frank that has not been used, invoked by the Securities and Exchange Commission for 15 years. The Obama administration, the first Trump administration, the Biden administration, and again, the second Trump administration. For 15 years, the Securities and Exchange Commission, under leadership of both parties, has found this to be such a low priority that it has not acted on it. The idea here is that we should apply some kind of statute of limitations or statute of repose on these unused authorities that because they're unused, just create uncertainty. It is impossible for businesses to actually provide the services that they're offering with this overhang of uncertainty that's out there. So this is kind of a reasonable policy position that should be bipartisan. If this is such a low priority for the agency, the authority should expire at least after 15 years. And then in terms of my colleague, the gentleman from California, I'm sorry he left because I want to make sure I understand his argument. He is suggesting that mandatory arbitration clauses are not voluntary. Well, in fact, that's not correct at all. These are private agreements voluntarily entered into by parties. What the gentleman from California seems to be arguing, is, if I hear him correctly, is that a contract is not voluntary unless a party can breach that contract whenever he or she wants to after there has been an offer, acceptance, and consideration and a final contract. That pretty much does away with all contract law in America. If there is an offer, if there is an acceptance, if the parties enter into that agreement and they have voluntarily entered into agreement to contract away the right to go to court in exchange for a better system for both the company and the investor, an expedited arbitration process that, oh, by the way, saves costs, which means better returns for the investor, and in many ways better consumer protection, that is an offer, an acceptance, and consideration. Why should the parties then be able to just breach the contract at will after they enter into that contract? We wouldn't have contract law in America if that was the rule. And so I would just urge all of my colleagues, whether you're Republican, Democrat, whatever side of the aisle you're on, this is pro-consumer, this is pro-investor. It's a more efficient, it's a more cost-effective alternative to litigation, which, by the way, on average, if there's a dispute that goes to court, you're talking about 2 years of pre-litigation, 2 years in court, maybe an appeal. If there is a legitimate meritorious grievance that an investor would have against a broker-dealer, why shouldn't they be able to agree to a more expedited process where they get their grievance resolved on a more efficient basis? Why shouldn't investors be able to agree to a process where there won't be as much cost that would take away from or deprive them of the returns that they ordinarily otherwise would get? So I urge my colleagues to consider those arguments. I think it makes sense to allow these discretionary powers to expire when they're not used for 15 years, and to reinforce the arguments made by my colleague from Missouri. A blanket fiduciary standard would make it very financially unviable for many broker-dealers to serve retail investors. And so what we're doing is we're eliminating this provision that could totally do away with a commission-based service that is cost-effective for retail investors, and that if we don't protect that, could leave many retail investors without any professional advice whatsoever. And with that,